What is law? This is one of the big questions raised by the idea of Internet law. Most people probably think of law as something written down in a statute book or court opinion, that is, codified or encoded in an official writing. Many people might add that law is issued by a sovereign, such as a king, judge, or legislature. In the study of jurisprudence, we think of positive law as man-made law, in contrast to divine or natural law, and we start to assess the legitimacy of the rule of law in terms of whether the positive law is publicly accessible, consistent with broad principles of justice, and issued by a proper sovereign under principles that govern the sovereign as well as ordinary citizens. The reference to divine or natural law demonstrates that positive law is not the only possible kind of law. Whether there really is some kind of divine or natural law, obviously, is a hotly contested claim with a long history. But every sane person agrees that there are some forms of law besides positive law that govern human conduct. For example, if you jump from the roof of a tall building without a net or other special equipment, you will fall to the ground and hurt yourself. No sane person believes that he or she is exempt from the law of gravity. And even if you do believe this, you will soon find you are painfully mistaken. So, there are at least some laws of nature that constrain human conduct. Or, at least we commonly refer to phenomena such as gravity as laws of nature, even if philosophers of science debate the concept. We also know from experience that we are subject to private agreements and social norms that shape and constrain our actions. Maybe you are listening to this lecture at home in your underwear. When we meet together as a class, you will certainly be wearing more clothing. One reason why is that the law school has some basic conduct policies that would preclude showing up for class in only your underwear. These policies are part of an agreement between you and the law school, even if you otherwise could stroll around in your underwear without violating a public exposure statute. A form of private ordering constrains your conduct. Alternatively, let's say you have a side job of performing at parties as a clown, and that you are listening to this lecture at home while wearing your favorite clown costume. When we meet together as a class, you will probably be dressed in the sort of neutral, casual clothing considered appropriate for law students. Why not wear your clown costume to school? There's no statute against wearing a clown costume to class, and it probably wouldn't violate any school policy. The main reason why you probably won't do this is social convention. If you wear a clown costume to school, your colleagues and professors will think you're, well, a clown. You'll face some degree of ridicule and ostracism, even though there's no inherent difference between clown pants and a pair of jeans when it comes to covering what's underneath. There's a social norm that constrains your conduct. In addition to positive law, then, we have identified at least 3 other sources of constraints that could be considered forms of law: laws of nature, private ordering, and social norms. All 3 of these additional sources come into play in connection with Internet governance. At one level, the notion that the laws of nature constrain human conduct in relation to the Internet seems obvious. How could they not apply? But recall our reference to the influence of science fiction literature on our concept of cyberspace. We imagine cyberspace as a place that frees us from the ordinary physical constraints of time and motion. In the real world, I may be a middle-aged law professor from New Jersey, but in some virtual world, I may be a demigod who controls vast armies of orcs. Alas, however, ultimately cyberspace also is subject to the laws of physics and mathematics. That is, at least, the communications network that makes it possible for me to assume the character of a demigod in an online game remains a physical thing, and the information that is communicated in relation to the game is subject to the laws of the conservation of information. At the physical level, cyberspace does not change the properties of the light and electricity that carry the game information, and the properties of the fiber optic cables and wireless radio frequencies that permit a carriage of certain bandwidths of light and energy. At the content level, the game's semantic content cannot be infinitely compressed without losing meaning. Consider this sentence: I am Professor David Opterbeck. Including punctuation, this sentence contains 31 characters that communicate a substantial amount of information about me. We could think of various strategies for compressing the number of characters used to communicate the same information. If we had a rule that said P means professor, and capital letters are personal identifiers, we might compress the message to capital P, capital D, capital O, PDO. If carriage bandwidth is limited, this sort of compression allows larger amounts of information to be communicated more quickly than would otherwise be the case. But compression can entail a loss of data. If we compress the message to just the letter P, it could communicate the title professor, but not the personal identifying information in the original message. Information theory involves mathematical algorithms that compress information as much as possible with as little lossiness of data as possible. These concepts are important for our discussion of Internet governance because the network possesses limited bandwidth and therefore requires algorithms, protocols, or code for data compression. These protocols or code elements must be common across the entire network, or else the compressed data will come out the other end as gibberish. In addition to algorithms for compression, the Internet requires algorithms for translation. Let's say I want to tell my friend Hernando, who speaks only Spanish, that I am hungry. If I say, I am hungry, Hernando may not understand me. He needs to hear me say, tengo hambre. We can make this work using a translator. Similarly, I may want to send the message tengo hambre to Hernando electronically. I may want to use a Microsoft email client on my IBM laptop, which is connected to my home wireless network, and Hernando may want to receive messages from me using the email client on his Apple iPhone, which is connected to a cellular network in Ecuador. In the old days of computing, this sort of cross-platform communication might have been difficult, if not impossible. It is easy on the Internet, however, because the network employs common interconnection protocols. In fact, arguably, these common interconnection protocols define the Internet. To connect a device to the network using these protocols is to be on the Internet. An early generation of Internet scholars, activists, and theorists could be considered cyber exceptionalists. They thought cyberspace was and should forever be ungoverned. This perspective is reflected perhaps most famously in John Perry Barlow's Declaration of Independence for cyberspace. Barlow proclaimed, "Governments of the industrial world, you weary giants of flesh and steel, I come from cyberspace, the new home of the mind. On behalf of the future, I ask you of the past to leave us alone. You are not welcome among us. You have no sovereignty where we gather." But the role of compression and interconnection protocols in cyberspace quickly led another generation of cyber law scholars to argue that, in cyberspace, code is law. Cyberspace scholar Lawrence Lessig suggested we should expect a future of control in large part exercised by technologies of commerce bracketed by the rule of law, or at least what's left of the rule of law. Lessig argued that, in real space, we recognize how laws regulate, through constitutions, statutes, and other legal codes. In cyberspace, we must understand how a different code regulates, how the software and hardware, i.e. the code of cyberspace, that makes cyberspace what it is also regulates cyberspace as it is. As William Mitchell puts it, this code is cyberspace's law. Lex informatica, as Joel Reidenberg first put it, or better, code is law. Yet another generation of cyber law scholars questioned the premise that the control over code was a form of law unique to cyberspace. As Jack Goldsmith and Tim Wu stated in their book Who Controls the Internet? Illusions of a Borderless World, when government practices control through code, it is practicing a commonplace form of intermediary control. What could be considered a third generation of cyber law scholars responded by suggesting that Internet governance should be a global issue with some degree of coordination by an international body. Some of this third generation thinking is evident in the WSIS principles we considered last week. Of course, you should not think that later generations of cyber law scholarship have replaced earlier thinking. While there are few cyber utopians today, there is a broad range of thought about whether and to what extent cyberspace is a unique space, whether and to what extent national governments can or should control Internet infrastructure, and whether and to what extent international organizations should coordinate Internet governance. The European Commission communication document in your readings on Europe's role in shaping the future of Internet governance is a good example of the tensions inherent in thinking about international coordination of Internet governance. You should note that this document does not establish any binding legal rule in the EU or otherwise. Nevertheless, it reflects the policy position of the European Commission as the central coordinating governing body of the EU member states. Notice the 5 principles of the European vision for Internet governance on pages 2 and 3. 1. Promotion of fundamental rights and democratic values. 2. A single unfragmented network subject to the same laws and norms that apply in other areas of our day-to-day lives. 3. Governance by a genuine multi-stakeholder model. 4. A strengthened and reformed Internet governance forum. And 5. A globalized ICANN and IANA. If you are an American or European lawyer thinking about these values, you might find all or most of them congenial. But of course, even then, the devil is in the details. What precisely is meant by the platitude fundamental rights and democratic values? How would such values relate, for example, to the Yahoo Nazi memorabilia case we discussed last week? How would they relate to the problem of government surveillance, due process, and the prevention of terrorism and crime? Even more interesting is the view that the Internet should be a single, unfragmented network subject to some form of standard legal principles. One of the biggest concerns of Internet internationalists is the fear that the trend towards creating walled gardens by repressive regimes will accelerate. For example, commentators often speak of the Great Firewall of China. That is, efforts by governmental authorities in China to block or filter which sites are accessible to Chinese Internet users. Similar efforts have been undertaken by some Arab, Asian, and African countries. From a Western perspective, we recoil, and I think rightly recoil, at, say, the thought of young Afghan students being barred from American or European sites that discuss women's rights. But what if Afghan religious and cultural values differ fundamentally from Western secular values? Does the phenomenon of the Internet legitimize the imposition of the secular values of the global North on the more traditional religious values of many populations in the global South and Middle East? Is a single unfragmented network something to be imposed or something to be proposed? The European proposal to globalize ICANN and IANA raise other sorts of thorny questions, at least from an American perspective. As you've seen in your readings, in many ways the domain name system is considered the backbone of Internet governance. A domain name is your address, your place in cyberspace. There is a sense in which, without a domain name, you are homeless in cyberspace. Yet, from its early days, the DNS has been legally under American control. ICANN today remains a California nonprofit corporation with a contractual relationship to the U.S. Department of Commerce. Think about it for a moment. The entity most directly associated with Internet governance is a California nonprofit corporation subject to California law under contract with the U.S. Department of Commerce. Some American observers think this is a good and necessary thing. Only in March 2014 did the Obama administration announce that the U.S. would relinquish its oversight of ICANN. Some conservative commentators, such as the Wall Street Journal's L. Gordon Kravitz, think U.S. oversight of ICANN is necessary to protect the network from authoritarian regimes. As Kravitz stated after the Obama administration announcement, the U.S. role in protecting the open Internet is similar to its role in enforcing the freedom of the seas. The U.S. has used its power over the Internet exclusively to protect the interconnected networks from being closed off, just as the U.S. Navy protects sea lanes. Imagine the alarm if America suddenly announced that it would no longer patrol the world's oceans. Are Kravitz and other conservatives right about American protection of the network as a sort of strategic global resource? Or are the Europeans right? Should the Internet be thought of as a kind of world cultural heritage resource that should be coordinated through an international body such as the United Nations? Part of the political rhetoric surrounding this question has focused on the U.S. National Security Agency's surveillance program, evidenced by the documents exposed by Edward Snowden. If you take the third module in our cybersecurity course sequence on national security, you will consider the issues raised by the NSA program in detail. For now, note that many observers think the U.S. wants to retain as much control as possible over the Internet, primarily to facilitate spying. It would be naive to deny that there is some truth to this claim. The Internet is a strategic geopolitical resource, and every ambitious nation-state, as well as non-state actors such as terror groups, at every moment actively engage in military and intelligence activities in and around cyberspace, including the member states of the European Union, notably Germany and the UK. These observations bring us back to the discussion of bandwidth, architecture, and code at the start of this lecture. If the legal and geopolitical landscape of Internet governance is muddy, can the technologists and engineers provide clarity? That is what groups such as the World Wide Web Consortium, or W3C, hope and believe. W3C was founded by Tim Berners-Lee, the person who invented the World Wide Web, and it is the world's leading Internet standards organization. The W3C website states that most W3C work revolves around the standardization of web technologies. To accomplish this work, W3C follows processes that promote the development of high-quality standards based on community consensus. All stakeholders can have a voice in the development of W3C standards, including members large and small, as well as the public. These norms reflect the academic communities from which the W3C originates. The W3C's patent and copyright policies, for example, generally require working group members to offer open-source licenses to any patent claims or copyrightable works arising from their contributions to the W3C process. Certainly, the open-source ethos reflected in the W3C process helped facilitate the rapid growth of today's Internet. At the same time, private companies with closed or partially closed source intellectual property models, such as Google in the all-important search space, have also contributed to the Internet's growth and usability. In our next class, we will look a bit more closely about how markets govern in cyberspace. As we will see, there are some potential areas of complementarity as well as potential areas of tension between open-source models and markets. For now, consider the question of how a technologist-driven, open-source collaborative model relates to the enormous governance problem of security. Proponents of the open, collaborative model argue that it produces a more stable and secure end product because the work of checking for bugs and holes is broadly distributed. But others note that it may be naive to assume that the voluntary social norms that unite an open-source community will supersede the interests of national or non-nation-state actors who desire to exploit the end product. In direct terms, how can we be sure that there are no spies or covert terror cell members working within a group like W3C to discover, hide, or even create security vulnerabilities? In equally direct terms, is it in the national security interests of a global power, such as the United States or China, to allow a multinational group of technologists to run the global Internet code and infrastructure? These kinds of questions are basic problems in Internet governance. This is the end of the lecture.